I've actually got one client. They happen to be in the business of managing the stocks for their clients. And so they will call me every once in a while and say, we're ready to do a GRAT. We want to fund this thing tomorrow. We're putting 100,000 shares of stock X in. You know, they're watching it. They think it's at a low price. And a week later, they might call me and do 2 more. And so at any given time, I don't know how many are out there right now or have wound down. But you know, they played it well. The other thing I've found as well, especially when the rate is so low at 1%, you know, when a client, you know, especially the very, very wealthy clients, you know, clients who are worth 50 or $100 million, you talk to them, you know, you should put $10 million into a GRAT. And if you do the math, it can transfer, you know, $2 million over X amount of time. Well, out of 50 or 100, that's not a huge amount. That same client, if you put enough in and you have a winner, you can move a huge amount in a short time. And I always tell them, you're getting your money back. If you put $50 million into a GRAT, you will get your 50 back plus 1% interest on it, which is probably better than you're getting in the bank. So you will get that back. But if that 50 goes up 10%, you just moved $5 million to your kids. Had you done a $10 million GRAT and it went up 10%, you moved $1 million. I mean, it's all scale. I actually have a client that said, oh, that makes sense, and that's where he came up with this 50 just now. He did 50. He has a large concentration in this one particular stock because they sold their company to a public company. And they funded it at 50. They went to 58 million, and he bought the stock back and locked in the gain. So in literally 6 months, we moved $8 million. Now he just has to live for another year and a half, and we told him he can't leave the house. But it's something to keep in mind. You know, the larger scale, the more you can accomplish in a short period of time. So let's talk about disclaimer GRATs. So this is how to travel in time. What would be great is, it'd be great if I could say, well, you know, Apple was like at $500 a few months ago. Now it's at $750. Wouldn't it be great if I could fund a GRAT today with Apple stock at $500? So is there a way to do that? And 2518 has rules about qualified disclaimers. And the effect of a qualified disclaimer is that the person who received the property is treated as never having received it. So if I pass away and leave property to you, and you sign a document saying I disclaim it, it then goes to whoever the next taker was, and you're treated as never having received it. And the reason for that is they don't want you to be treated as having made a gift. Otherwise it's estate tax, and then a gift tax, or whatever it might be. So if you make a qualified disclaimer, basically within 9 months, haven't accepted the property or its benefits, didn't drive the car for a few weeks, then disclaim it, didn't move into the house or spend the money, then you can make a qualified disclaimer. And where I've used this is in a GRAT. So what if I transfer assets to a marital trust for my wife? A general power of appointment marital trust. So I don't even need to make a Q-tip election for it. And that trust says, into the trust agreement, if my wife disclaims any of the assets I put in here, makes a qualified disclaimer, then it comes out of the trust and goes to GRAT A over here. In fact, even better, I fund it with 3 different stocks. It says if she disclaims stock A, it goes to GRAT A. If she disclaims stock B, it goes to GRAT B. If she disclaims stock C, it goes to GRAT C. 8 months later, and I funded it with Apple stock, the marital trust, with Apple stock at $500 a share. 8 months later, the Apple stock is trading at $750. What does she do? She disclaims the Apple stock. So it's a qualified disclaimer. It's treated as if it never went to the marital trust, treated as if it went to the GRAT on day 1 back in March or whenever it was. And by the way, this GRAT needs to be existing and signed. I would sign it. So it's in place. You can't draft it quickly after the fact. And so it's treated as if it went there on day 1. Oh, and then by the way, stocks B and C that I put in, they went down, so she doesn't disclaim those. They stay in a marital trust. They can be distributed out to her. We can do whatever we want at that point. And so on the gift tax return, we have 2 stocks going to a marital trust. IRS, if you have any questions about that, let us know. And then we've got stock C going to a GRAT, which according to a qualified disclaimer went into the GRAT back in March. and the stock was worth $500 at the time, and that's that. Whether you also want to disclose the whole thing, well, actually we put it in here and then disclaimed it. I don't see an issue with doing it. It is what it is. It's a qualified disclaimer. The gift tax rules say you can do it. The gift tax rules say what the effect is. The gift tax rules say it's treated as if it never went to that person and it went to the other one in the first place. So it's like a retroactive grat. And of course, the first time that I did this, the spouse who was the beneficiary of the marital estate died during the 9-month period. You couldn't stay with us for 9 months. And so we actually had to, we were able to go to court. The executor was authorized to disclaim. We got court blessing for the executor's disclaimer, and they disclaimed 2 out of the 3 stocks or wherever it was. And we filed the estate tax return, and that's been that, and that's been a few years now. So it can be, it's like the crystal ball grat. By putting in this marital trust, disclaiming the winners, keeping the losers, you can really, as if the 1% wasn't enough. now we can look back and do it retroactively in effect. So any questions on rolling grats, decreasing grats, disclaimer grats before we turn to the next topic?
Case law on decreasing grats?
Not that I know of. I haven't seen any rulings or anything on it. But we've been doing them. We've been reporting them on gift tax returns, and nothing's been set on any of them. And I don't know what they could say, the regs. They don't say explicitly you can, but they don't say you can't, and they imply that you can. Question back here? Yeah, if it's closely held stock, then I think you need to get an appraisal on every turn. So stock going in, if you're paying in closely held stock, get an appraisal coming out. Right, for publicly traded, just use that, which is why I hesitate to do closely held stock in grats. Right. Well, the legal expense I'll leave to the audience. Though, obviously, once you've done one grat for a client, and if they all pour it into the same receptacle at the end of the day, creating a second one is not time-consuming or difficult. The appraisal's the part that can cost. And sometimes when we've known we were going to have this potential series of appraisals, we've talked to the appraiser ahead of time and said, look, tell us what your initial appraisal is. We're going to want to update this, assuming the company is still the same company and just need new financial data. Often we get a discounted rate for the subsequent ones. But I do try to avoid paying annuities from grats with closely held, one, because of the cost and the hassle factor, but two, it's just additional risk. IRS says you're supposed to pay $1 million, and we think we think your valuation is off and you didn't pay $1 million. It's just one more issue floating out there. Any other questions? So, speaking of valuation risk, it seems to be the biggest issue, the biggest risk, I think, for the most part. I mean, we all know how to comply with the law and what you can and can't do with trusts and how to keep them out of the estate and how to structure grats and everything else. But what if we're off on valuation? And who's to say what the value of a closely held business is, let alone a house? The only thing we really know is value of publicly traded stock, and even then, that's just a number floating on the computer screen. Is it really worth what we're paying? And the cost of a audit that's successful by the IRS can be significant. Obviously, there's the taxes, the interest, the penalties, perhaps. But maybe the person now has to come out of pocket and raise some cash that they weren't planning on paying, and now they got to sell some assets to pay the IRS and trigger some gains. Or maybe they have to sell something and it's not a good time to sell that asset, but hey, I got to pay the tax. We had this gift tax that was unexpected. And there's been a series of cases, and especially in the last year or so, But in the last 50 years, going back to the Proctor case, where people have tried various techniques to avoid valuation risk. In the Proctor case, it was basically a gift to a trust, and the trust said if any portion of the gifted property was to be excluded from the transfer if a court held that that was a taxable gift. So here's this, but if court ever says that that's a gift, then never mind, send it back to us. And in the Proctor case, the Fourth Circuit said that's a condition subsequent. It's not going to be effective to avoid gift tax. We're not going to recognize that. And then there's a revenue ruling 86-41, where an adjustment clause in the trust required the trustee to reconvey the gifted property or to pay consideration if the IRS determines it was in excess of a certain value. And that ruling, the IRS also held that's a condition subsequent. So you can't say, here it is, but if this happens, then never mind, we take it back. And the issues they've had are obvious. It eliminates their incentive to audit. If they audit, then you just take it back and say, we still don't owe you anything. Now, on its face, there still is an incentive. That means assets came back into the estate where they're subject to estate tax eventually. So it doesn't completely eliminate their incentive to audit. I think that's what they do for a living, so they will always audit. So a number of strategies have been used over the years. For example, a marital formula. We all use them in our wills and revocable trusts. Upon someone's death, fund a marital trust and a credit shelter trust using a formula. And if we're off on valuation, it self-adjusts, and the IRS has always respected that. But it's partly because, it's a death. We don't know what the values are. We don't know what the assets are even going to be when we write the document. And so we just have to have a formula. And there's a downside to that. If you use it in a lifetime gift setting, say, well, here's the gift, and if any excess over X dollars in value goes to my spouse or goes to a marital trust, well, that means it's going to your spouse or to a marital trust, which, for better or for worse, as they say when you get married. So it may not be what you want to occur, and it's still unclear whether it's going to be effective. Are they going to recognize that during life? Then there's a charitable formula. So excess goes to charity instead of to spouse. And, hey, I get an income tax deduction while I'm at it. That's sort of taking the approach of I'd rather have charity get it than the government get it, even if my kids don't get it either. And we'll talk about the Petter case in a minute that used a formula along those lines. And then last, there's formula gifts. So I hereby transfer $1 million of ABC Corp stock to the trust. So it's a gift by formula. It's not a condition subsequent. I'm not saying I transfer 100 shares, but if it's worth more than $1 million, I take it back. It's I only transferred $1 million worth in the first place. And so I know it sounds like lawyer doublespeak. Oh, if I say it this way, then it works, and if I say it that way, it doesn't work. But that seems to be how things work. Condition subsequent was the issue with Proctor. And the problem with all of these is all they did was shift the words from one place to another. Now, formula gifts have been given effect as far back as 1986. There's a letter ruling where it said such interest in the partnership that have a fair market value of $13,000. And that, for whatever reason, the IRS blessed that one because we know since then they've attacked formula gifts. But more recently, we've had the McCord and the Christensen case. McCord was 2006. Fifth Circuit. Christensen was 2009. And both of those cases, they weren't exactly formula gifts tied to gift tax value. They were actually formula gifts tied to the appraised value. Because look, I'm trying to give this today. It's always the chicken and egg problem we have with our valuations. I want to give this today. It's going to take 6 weeks to get an appraisal. So I don't know what the value is today. But if I wait 6 weeks, then the value might have changed, especially if it's like an FLP with marketable securities. So when do I do it? If I do it now, I'll never know the value on the day of. So what they did, they made the transfer tied to the appraised value. So I'm transferring $100,000 worth based on the appraisal that we will have in 6 weeks, and we will adjust based on that. And the IRS said, yeah, we'll, and the court said, we'll respect that. You weren't trying to do anything. There was no funny business. It was just the practicalities of the situation. But then we got to the Petter case, which is 2009, and then it was affirmed in 2011 by the Ninth Circuit. And that was a formula gift and sale by Ann Petter. So she set up a limited partnership, and she made a gift of limited partnership units to trust for her kids, and a sale to trust for her kids. But actually, the gift and the sale both said, I'm transferring 100 units, and I want X dollars worth to go to the trust for my kids, and I want the rest to go to this charity. I'm parting with 100 units one way or the other. So it's not $1 million worth. It's, here's 100 units. You guys need to sort out how it's going to be divided among you. And in that case, the charity actually was not a private foundation. It was a third-party public charity. Actually, it might have even been a donor-advised fund, but again, third-party public charity entity. And they got involved, and they looked at the valuation and commented on it and said, okay, we think the division should be we get this amount and you get that amount. And they didn't structure it so that the charity got nothing. They structured, charity was going to get something. It was just a matter of how many units. How is this going to be divided? And so they would reallocate, and they sold units on the same basis. Here I'm selling 8,000 units, and I want X dollars worth to the trust, and anything over that should go to charity. And ultimately, the tax court agreed with the Petters. They said the formula clause is valid, transferred a fixed amount to the trusts, and by the way, this was not based on the appraisal. This was based on the value was finally determined type of language. And the excess amount that went to charities qualified for the charitable deduction, and an income tax deduction for that matter. And they said this is not the same thing as trying to take property back. This was a fixed transfer. They weren't trying to undo a transfer like in Proctor. They also said we're not convinced by public policy arguments that there's no incentive to audit. Well, first of all, this involved charities, and there's an incentive to give to charity, and we want to encourage that. And also, they pointed out, formula clauses are commonly used in planning, in testamentary planning, in GST exemption allocation. Qualified disclaimers can be done via formula, as the regs say. So that was a great case. McCord we were all looking at, but McCord at the end of the day was really tied to appraisal, not final value for gift tax. The Petter case went a next step, and it was final value, but there was a charity involved. Was that what carried the day? There was unrelated third parties that could negotiate. It wasn't just me deciding with my appraiser and my kids and so forth. But then we get the Wandry case. That's a tax court case that came out earlier this year. And that one was, and they cited Petter, that was just a flat-out, we transfer that number of company was called Norseman units, that the fair market value of such units for federal gift tax purposes was equal to X dollars. So they did a formula tied to dollar value. That number, and it wasn't, here's 50 units. It was, I'm not even saying how many units of this, or shares of stock of this company I'm transferring. All I'm telling you is I'm transferring X dollars worth as finally determined. Because we don't know what the final value is. I'm just trying to transfer $1 million. Can't I just do that? That's what we'd all like to do. And the documents went further, and they said specifically, although the number of units gifted is fixed on the date of that gift, because we need to transfer something, that number is based on the fair market value of the gifted units, which cannot be known on the date of the gift, but must be determined after such date based on all relevant information. And if the fair market value is determined by the appraiser was different than is adjusted by the IRS or court, then the number of units would be adjusted. So we're transferring $1 million worth, and here's what we're going to do for the time being. We got to document some stock transfer somewhere, but this is based on what we think the right answer is, and if it turns out it's the wrong answer, then we will readjust. We're not taking back. We just didn't calculate the right number in the first place. And the tax court agreed with the Wandrys, and all their actions reflected the transfer. They demonstrated intent to make a gift based on a dollar value. The main issue was the defined value clause. Was it valid? And the court cited Petter in saying there's a distinction between a savings clause, which is void. Here it is, but if this does anything wrong, then never mind, we take it back, as opposed to a formula clause, which is valid because it transfers a fixed set of rights with uncertain value. And this couldn't have been better written if we had written it ourselves. Each donee was entitled to defined percentage interest expressed through a formula. The Wandries were not entitled to take any portion of the gift back. And the court dismissed the public policy arguments against defined value clauses, saying there's no public policy concern that's severe and immediate enough to justify invalidating defined value clauses. And then they went one step further just to make sure we were happy with the ruling. And they specifically noted that it did not make a difference whether a charity was involved. So to the extent we thought, well, better, if we want to involve a charity and do all of that. But this one, it flat out blessed the formula gift based on a dollar value. And I've been doing these. Now, Wandry is subject to appeal, so we don't know where it'll go or what the result will be, but at least we know where the tax court stands. It couldn't have been a better case. So now we get to the topic, which is the chapter heading, the LPA lid. So LPA stands for limited power of appointment. And we know that if I make a gift to a trust for my kids, but I retain a limited power of appointment over the trust, the power to direct the trustee to change the division of the assets among the kids, to redirect the assets out to some other person or charity or anyone else, a limited power of appointment, then it's not a completed gift. Section 2522, the regulations say a gift is incomplete if the donor reserves a power in himself to name new beneficiaries or to change the interests of the beneficiaries as between themselves. So, lesson one, don't retain a power of appointment over your trust, or a gift is not complete, and it will be included in your estate. So how does this help us with valuation? We've used something called, what I call the LPA lid. It's intended to be a power of appointment putting a lid on the value of the gift. And in this structure, we're not transferring an uncertain amount. We're not redirecting anything to charity or to spouse. We're not creating a formula, all of a sudden a spring note, which we've also had. There's the King case that said, I'm selling, and if we're off on the sale price, then we'll adjust the note. But instead, it's a provision built into the trust that says, if a gift is made to this trust, and the gift is in excess of the amount stated by the grantor, or maybe you put in the trust itself, that we're going to put $1 million gift in this trust. So if anyone makes a gift in excess of $1 million to this trust, then that portion of that gift, the donor has a limited power of appointment over it. So the trust stays intact. We put 100 shares of stock in. It's a gift. If the 100 shares of stock is worth more than $1 million, then I have a power of appointment over that excess piece. I don't have a power of appointment over the other one. We're not redirecting it to spouse or charity. We're not taking anything back. We're not readjusting the number of shares. It's all in the same place. But, make my math easier, if it's $1 million, or I thought it was $900,000 going in, turns out the IRS says it was worth $1 million. Well, 10% of the trust is in my estate, and 90% of the trust is out of my estate, but there's still no taxable gift. This was a gift that was within my exemption, or whatever I was willing to pay gift tax on, and this other 10%, this $100,000 swing, according to the trust document, I have a power of appointment. And it's not my doing that it's not a taxable gift. That's just the gift tax regs. I didn't write them. I didn't say that if they're the ones that say that it's not a taxable gift, even though I've parted with control. I'm not getting the assets back. Yes, I can redirect those assets to someone other than myself. I do that out of caution. I think if I could point it back to myself, it starts to look like I have the right to just take it back. So I've parted with it. It's an asset of the trust. The trustee has fiduciary duties. It didn't move to anyone else. I didn't undo anything. And it's a technical rule in the gift tax section that says it's not a completed gift. And just like the technical rule of I can make a qualified disclaimer and it's retroactive, the rule's the rule. And so what I like about it is its simplicity. It's just sort of in the trust. It's there. I've used them in conjunction with formula sales or formula gifts. So here's a gift. We're only transferring $1 million. For some reason is not successful in working. Wandry's overturned or what. And they say your $1 million gift wasn't $1 million, it was $1.1 million. Then I've got, okay, well, I guess it's in there. We didn't undo anything. 100 shares are in the trust. But according to this trust, I have a power of appointment over part of it, so you can't tax me on that $100,000 piece. Obviously, as the trust grows in value, 10% remains in my estate. If that million grows to 10 million, then $1 million is in my estate, not just 100,000. But I did head off the gift tax if the client doesn't want to pay the gift tax. It is worth having that discussion, by the way, with clients. Paying gift tax is efficient. It's more efficient than putting it back in your estate. Just no one wants to write that check, understandably. I've had a few clients, obviously they're at the higher end of the spectrum. They've got a lot of liquidity that I've brought it out to. There's certain ones I know they'll throw me out of their office if I suggest paying tax early. But I have suggested making taxable gifts. Here's all the things we can do. We can do backflips and handsprings and grats and sales and all these other things. Or we can just write a check over here. And if you compare the two, they're not even going to be close. The taxable gift is going to win hands down, even when you figure in, okay, well, this one had to pay gift tax, and so we have less to inherit later on. Well, this one had more in the estate, and so there's more estate tax. And the reason it's better is, number one, the growth in income is out of the estate, as we all know. But two, the gift tax, if you recall, is calculated differently. So even though they're the same rate, the gift and estate tax rate, the estate tax is inclusive, the gift tax is exclusive. Translation, let's assume they're both 50% rate to make our math easier. If I want to leave my kids $1 million at death, I need to start with $2 million, 50% tax, kids, here's your $1 million. If I want to give them $1